Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about a real-life case with real-life clients, real-life facts, though of course names are altered for confidentiality purposes. So for today's episode, we're going to be talking about some of the problems that I see when people try to do their own property transfers without seeking professional help or guidance. And when I say property transfers for this episode, what I mean are things like houses and land, like farmland, etc. So we're not talking about money. People have no idea that transferring property comes with a very unique set of rules and laws. Scary enough, in my personal opinion and professional opinion, I guess so too, the way many things in property world work is that you do not technically need a lawyer involved. So the question here is, should you? An insider secret, the answer is yes, for the love, yes. And I think this episode will show you a few examples of why the answer is yes. Today, you're going to get 3 mini stories, 3 for the price of 1. So not just one long one today. Hey, and if I can come up with 3 mini cautionary tale stories of things that have actually happened recently to clients, then that probably goes to show you the depth of this issue. And guess what? 2 of the 3 stories did not have lawyers involved when the property transfers occurred. But guess who had to get involved to clean those 2 up? Lawyers. And probably for more than what it would have cost the lawyer to do it right the first time around. So alrighty, let's dive into mini story number 1, and it's going to be about property titling. So I had a referral from a friend and professional contact that works at a title company. And super long story short, they were helping, let's call her Melinda with title work for the sale of a property. Melinda's ex-husband, who she was actually very amicable with, had passed away. And I won't bore you with the nitty-gritty details, but basically, Melinda had hired a realtor, signed a contract with the realtor, got and accepted an offer, and they were nearing closing. The title company noticed something a little strange, and to this day, I think the title company referred them to me because I think they knew what needed to happen and they didn't want to be the bearer of bad news. So I gathered all the facts and realized that because of the property ownership, Melinda's ex-husband's estate needed to get probated. What happened, in the shortest version ever, was the property was owned with Melinda and her ex-husband as husband and wife. When they got divorced, they never touched the property titling. They did the divorce without attorneys involved, which, hey, that is fine. I know that happens sometimes. The issue is that the property titling should have been addressed at that time. You just can't assume things in my little legal world. So when Melinda's ex-husband passed, I started piecing together that, oh dear, this property defaulted to what is called tenants in common when they got divorced. That weird word, tenants in common, I guess it's a term of art, not just one word, that means they each own a half interest in the property. It did not automatically default in ownership to Melinda at her ex-husband's passing. To this day, I think she thought I could just whip up an affidavit or deed transferring the house to just her. No. Legally speaking, his half interest needed to get probated, meaning that closing was not going to happen. So I got to be the bearer of bad news, and honestly, it was not fun. Even though I had absolutely no relationship with Melinda or her ex-husband before this, meaning I was obviously not the cause of this messed up deed, I still felt bad. they thought, assumed that the property was still jointly owned after the divorce. But it was the divorce that severed that husband and wife relationship. Thankfully for them, Melinda's buyer, the house's buyer, was willing to be patient and wait until things got rocking and rolling in probate land. So when things got cleaned up, everything got taken care of, but boy, it was a doozy. And I sure think they learned their lesson. So on to mini story number 2. And this general topic, this general theme is transferring property for some bad reason. So I helped a client who is a gentleman in his early 60s that was recently put on hospice. He wanted to get his basic estate planning done, and near the end of the conversation, he asked me to help him with some deed work. And again, long story short, in 2017, he had transferred a property to his 20-something-year-old daughter. When I asked him why he did this, because I was like, in my brain, I was like, that is so strange. So I asked him why he did this. And he said his real estate attorney said that if he did transfer it to his 20-something-year-old daughter, it would avoid inheritance taxes for his daughter when he passed. And I quickly interjected and asked, when was this transfer done? And he said, 2017. And I said, well, we haven't had inheritance tax since 2012, so you got some bad advice. Oddly, he seemed to shrug it off. In my head, I was thinking, well, I'd be ticked off at that real estate attorney, but okay, buddy, I guess if you don't care, I shouldn't care. He proceeded by saying that he wants his daughter to transfer it back to him because he didn't realize transferring it to her would cause him to lose like the property tax exemptions, like the homestead exemption and mortgage exemption. Again, I was thinking, well, yeah, I could have told you that. So following this meeting, I proceeded to pull the last deed and have my office prepare a deed transferring the property back to this gentleman, meaning his daughter would have to sign it, not him, since after all, she was the property owner. So this meeting takes place, and I learn a few days later, after my office incurred expenses of pulling the deed and preparing the deed, that the daughter was planning on refusing to sign the deed, even though her dad was paying the mortgage on the property because the mortgage was still in his name, and he was paying the property taxes. Oh my gosh. So he asked me, Jenny, do I have any leverage? And I said, well, I guess you could stop paying the mortgage and expenses and see if she ponies up the cash to start paying them. Because then if he stops paying the mortgage, the bank's going to foreclose on the property, and since she's the titled owner, she'd definitely have to get involved. It's beyond me that this is a father trying to work things out amicably, and his daughter, who is a 20-something-year-old stubborn individual, obviously. To be honest, I don't have how this story ends up. I'm kind of in the middle of it right now. So we'll see. But things are not looking good for old dad. She's the titled owner. Period. End of story. She is holding the cards, not him. So lastly, on to mini story number 3. And this topic, this theme, is transferring property based on like goodwill or trust. So this one, it just leaves me scratching my head. When I heard about this happening, I was thinking, what? So my husband, who is an attorney at my law firm, met with a lady that during their conversation, it got brought up about a piece of property. And I think if I remember correctly, it was like a parcel of farmland. So she proceeds to share with my husband that many years ago, her and her now deceased husband purchased this property from a neighbor. And they thought, oh, they don't need those silly lawyers involved. We've got this. So they gave the neighbor money for the land, and the land was theirs. So she thought. At that time, she shared that they were unsure of how to title the property. Whether they should put it in both their names or just one of their names or in their kids' names in case nursing homes get into the picture. And little side note, Legal Tea listeners, do not do the whole transfer property to your kids' things for like 1,000 different reasons. You'll get creamed in taxes and it won't work for Medicaid. So anyway, they went into what this lady and her now deceased husband, they went into something that I like to call analysis paralysis, where basically someone stews about something for so long that they just freeze. They don't move, and that's exactly what happened. Then life must have gotten in the way because they never actually transferred the property into their names. You heard me right. So money got exchanged and they never transferred the property. So my husband proceeds to somehow contain his shock and continue asking questions. Okay, so what's up with the neighbor? Are we still cool with him? She said, oh, he died many years ago. I'm sure my husband was thinking, great. My husband has not had the ladies' next meeting to figure out exactly what she and we are going to do. But I'll tell you what, she's got very limited options available. I'm fairly confident that the farmland will get into her name, do a little cleanup all these years later. But to do so will either, one, be a obnoxiously long, hard, annoying process and costly, or two, somewhat short, as long as everyone is on the same page process, less costly. We'll sure see what happens with this case, but I think this case, as well as the prior two mini stories, shine a big old light on property transfers. I had a realtor friend say once, I do not understand why people are so careless with property. Oftentimes, a house is a person's biggest asset. Heck, if you have farmland or rentals, it amplifies this point. So why do people not get professionals involved when doing property transfers? That's what he said. And he's so right. People do their own deeds that they pull online or pull from the county recorder's office. If they do it wrong or assume something is not accurate, they have no idea the consequences of their action. Whether it be a consequence they deal with in their lifetime or the lifetime of the kids, the beneficiaries that have to clean it up much later. If it's not done right and not done well, someone will have to clean it up eventually, either you or them. And I feel like I've talked about this so many times on Legal Tea, but yet again, if I, the lawyer, have to play cleanup, it is not fair to assume that me, the cleaner-upper, will give you a break. Heck, oftentimes I'm having to work harder, which requires more time on these kind of cases. Why would I not charge more than, say, someone that did seek professional help regarding property transfers and it went well, it went right? Why would I not charge that person more? Lastly, when you think about these stories, you have to weigh the cost of then and now. Had any of these stories sought professional assistance before they fiddle-farted with the property record? Yes, they would have spent a little money. We charge a few $100 for a deed, per deed. So a few $100 to have the peace of mind knowing that what was done right. Compare that to not spending anything initially, but the cleanup of all three of these stories are way more than a few $100s. It's just that simple. We're cleaning up, dare I say, a little bit of a mess, or a lot of a bit. Alrighty, let's wrap up this episode. Next week, we are back to the current events, current trends topic. So something I've seen or run across that I think would be interesting to chat about on here. During that episode, we're going to be talking about rental properties. And I feel like it is a very timely topic because does it not feel like everyone and their brother are buying properties to make rentals? Maybe it's the hot thing to do. Maybe it's the housing market to blame. I don't know. Nonetheless, we're going to be talking about rental properties and incorporating them into an estate plan next Tuesday. So until then, be well and talk soon.